Let's move on to the next item. Protection for participation in trade unions. Welcome, deputations. May I remind deputations that you have 3 minutes, and please don't use cocktail language, stick to one language, please. And your speech is not protected by the Powers and Privilege Ordinance. We have 14 deputations. You'll be asked to speak later. And after that, I'll open the floor for questions from lawmakers. And then the administration will reply to them. May I first invite deputations to speak. First, we have from Hong Kong Human Rights Monitor, Mr. Loh Yuk Kai. Under our constitution, it's very clear that trade unions' rights are protected. It's under Article 27 of the Basic Law. And other rights are also protected under the Basic Law, Article 27 and 39. Some other labor legislation around the world are also in place in Hong Kong. For example, number 87, Convention 87, and number 98 about collective bargaining powers. These are all for protection of union rights. However, it's regrettable that when it comes to enforcing them, we see lots of problems in Hong Kong. We need local legislation before we can comply with the international legislation. At present, any employers taking away the freedom to associate, to assembly of workers will not be allowed. Any discrimination because the workers participate in union activities will not be allowed, and that's actually against the law. But in recent cases, we see that enforcement is not exactly effective. The government is not regarding these as criminal offenses. For the burden of proof, it's not stated clearly in the legislation, so there are loopholes for employers. Now, workers who form unions, who take part in union activities, they will not be dismissed because of that. The pretext will be that they do not perform well. So the employers may do something unfavorable to workers who take part in union activities. The burden of proof rests on the employers. But the employers may say the worker is sacked because he does not perform well. For the employee to prove that that's not the case is very difficult. So in reviewing the legislation, the government should take on board the protection of unions. Next, we have Mr. Kingsley Tam from Hong Kong Federation of Trade Unions Rights and Benefits Committee. We have the freedom of association under Basic Law. Workers can form trade unions. The whole purpose for them to do so is to unite workers in order to safeguard their own rights. But recently, employers will make use of different ways to oppress those who are in trade unions. They may even dismiss the workers. The FTU is glad to see this issue is taken up in the panel. We have the following 2 points to make for the administration. We hope they will be taken on board. First, in case of labor disputes, the union's position to negotiate should be recognized by employers. 7 people alone can form a union. When we form unions, usually it's because there are exploitation of workers. That's why unions are set up to protect the rights of workers. When there are labor disputes or conflicts, unions can intervene, and in that case, the employers should recognize the legal position of the unions. The unions are set up under the trade union ordinance before it can be registered. So the employers should recognize the union's position to intervene in labor disputes. Employers will form their own liaison groups within the company. They may say it's better to go for prevention before any problems pops up. Yes, they have good intention, but these consultative bodies or these liaison groups actually see members who are appointed by the employers sitting there. They are not elected by the workers themselves. These are units where members are appointed by employees. We wonder if these units are actually rubber stamps. Next, law enforcement is really difficult. Burden of proof is for the worker to show that he is dismissed because he takes part in union activities. But the employers may use administrative means to whitewash the fact that the employee is actually dismissed because he takes part in union activities. The burden of proof on the part of the worker is really difficult. Next, Mr. Jerry Tam from Civic Party. Thank you. Labor law in Hong Kong is really not keeping up with other jurisdictions. This is the view of the court and also the unions. Hong Kong is an international city. Still, our labor ordinance is really outdated. This is really appalling. Professionals in Hong Kong, overseas professionals in Hong Kong are really shocked by this fact. Our government should face up to this problem and make an improvement. Labor disputes usually see employers take the lead in it, where the employees will be dismissed usually after the dispute. Let me give you a recent example. The Hong Kong School of Motoring. Experienced driving instructors are dismissed because they want to save money by employing those with lower wages. This is unreasonable. Workers have only limited financial means. They are treated unreasonably, and they cannot afford the high cost attached to legal proceedings, so they can only resort to unions for help. So we should have legislation to protect people taking part in unions, so that workers and employers can stand on equal footing. Before the handover, we were supposed to have the collective bargaining powers, but then it was dismissed, taken away. This is actually a step back. The government simply delayed matters with consultation, and up to now, they haven't even considered legislating for collective bargaining powers. This is really very disappointing to workers. After the handover, there were some amendments to the labor laws, for example, raising the penalty for dodging payments and imposing a minimum wage. But for the protection of unions' rights, you haven't touched upon that. I don't understand why. In 2009, at the meeting of the 20th of May, the Secretary for Labour Welfare, Matthew Cheuk, said, legislating for that may damage the power, and that will be inflexible, that will lead to adverse effects. But the government should not simply look at the interests of the market. It has the responsibility to protect the disadvantaged groups. They should not be siding with the business sector in exploiting workers. Our party urged the government to legislate for collective bargaining powers and to amend the TUO to protect workers' rights to join unions. Next, we have Manpower Concern Group's Mr. Wang Kwai Sang. I work in the Jockey Club. I've been on different unions, several unions. Last time I was at the CMAB meeting to make my point. Now let me give you further examples. Dr. Pan slammed the Jockey Club, and our company made an advertisement saying that, singing praises to themselves, saying that they are treating workers well. And I protest because I have hearing problems, job-related problems. And then another advertisement singing praises to themselves. They spend so much money just to set themselves against us. They are actually targeting the unions. We have problems every day. But I can tell you there are solutions. Amy from Jockey Club, the training school for riders, Miss Chen, is very good at playing badminton. She helped those jockeys who suffered from injuries. I hope the Manpower panel can talk to us, can talk to the unions. You have to talk to the right people. You may talk to people who will only sing praises to themselves in advertisement, which I don't agree with. Mrs. Rita Fan. Well, the election is off, so I can say this. Mrs. Rita Fan urges the business sector to do something good after making money. There are doctors, orthopedists in our company. In 1987, when I was working in the Jockey Club, my boss was very good to us, saying that we did not have enough rest. But things are exactly opposite now. After the handover, we have less and less rest. In 1974, the Jockey Club wanted to combat illegal betting. And since that was rolled out, I turned into this face, this mask here. Well, you could not injure a horse in the last century. How come they are doing all these injuries to my hearing? This is really cruel.
Mr. Lam Chong-ming, Labour Party. Chairman, I've got a couple of requests here. Under the employment ordinance for acts of discrimination against labor unions, nobody can make any claims. If a company deters someone from being involved in trade unions, then you can post him out in the stake, and nobody can make any claims. Now the BA, British Airways, it is really silly. It results to monitoring the workers. Welcome cleansing company, it forces the workers to resign. There is no dismissal, and there is no civil remedy at all. So the Labour Department urges the administration to amend the employment ordinance to protect workers in the attempt to form trade unions. They should be free from any discrimination. There would be full civil remedy. Second, the right to get reinstatement. Right now, the law doesn't provide for any reinstatement. Now, this is terribly important because this would safeguard the career of those taking part in trade unions, and this would stop the employers getting rid of the workers involved in trade unions. The government started looking into this reinstatement in 1999, 14 years on. What has the government done? Why is it that we haven't got any proposals in this regard after so many years? Third, the penalty, $100,000, and altogether they have to compensate the workers for $250,000. And the workers' salary can be to the tune of millions of dollars. I mean, even if you get rid of the trade unionists, all you need to shell out is $500,000. If I may put this to the Labour Department, how many complaints have you received regarding anti-union discrimination? How many cases have you prosecuted? Now, as the Labour Department, has it done anything to promote the rise of the trade unions? Would there be any subsidy for organizations to run activities to heighten awareness of protection against anti-union discrimination? And next, we move on to Mr. Lin Kwok, Hong Kong School of Motoring Driving Instructors Union. Chairman, when I tried to form a trade union, the company tried to crack down on it, and they did act on it. They did sack those who tried to form trade unions, and we did suffer all these setbacks. All these are plain facts, but it was very difficult for us to sue them. We lodged a complaint with the Labour Department. We've got no idea whether the Labour Department would prosecute them. If the government can amend the legislation to stop the employers evade their responsibilities, it would be a good idea. We hope that the administration will review the legislation to stop any crackdown on trade unions. In fact, they're suppressing the trade unions. Thank you. Thanks very much, Mr. Lin Kwok. Hong Kong Confederation of Trade Unions, and Mr. Poon Man Hon, Policy Researcher. Chairman, freedom of association, freedom to strike are enshrined in the law. The most important question is that other than a civil remedy, there is no civil remedy for unfair dismissal regarding trade union activities. There has been very little in the way of prosecution. I'd like to ask the Labour Department as to how many cases in which they have levelled charges. There are 4. There have been 4 over the past decade or so. The unions, from time to time, would receive discrimination cases. In December last year, Hang Seng Bank dismissed a number of security guards who try to form themselves into trade unions, and the government or the employers can do something about it as soon as they spot any unionization. What has the Labour Department done in this regard? The other thing which is important is the collective bargaining bargaining power. Back in 1998, the International Labour Organization urged the government to legislate and recognize the status of the trade unions. That 10 years on, more than 10 years on, what has the government done? We cannot see any progress in relation to legislating for the protection of the unionists. If I may put this to the Labour Department, how many workers are covered by the protection? We don't have any legislation for the time being. We may be talking about the consultation between the employer and the employee, but the employers can turn nasty in the process. Now, if I may put this to the Labour Department, how would you evaluate the effectiveness of this existing mechanism? The mechanism, as far as we are concerned, is terribly ineffective. We may have meetings, but if the employers don't do anything at all, there is nothing much we can do about it. Also, civil servants are being involved in collective bargaining. In reply to the ILO, it was said that civil servants should not be included in this collective bargaining mechanism, and this is a problem. Next, the Federation of Hong Kong and Kowloon Labour Unions, Mr. Ko Chun Kit. Is there a legislation to protect joining trade unions? The answer is yes, but this is not effective. This is almost like useless. This has been around for 40 years. Have we seen any successful prosecution? If this is regarded as harmonious labour relation, then you're wrong. You're playing wrong. If you ask the unionists, and they are putting the job on the line to run trade unions. If this legislation is effective, we don't have to do anything at all. Discrimination is getting serious. Many who are involved in labour unions are regarded as troublemakers, and they are interfered with, they're punished, or they are sacked. In extreme cases, we have come across so many cases of discrimination against trade unions. And there was a case in which a unionist was sacked, who was very active, and before he was dismissed, he tried to seek a pay rise for the workers. After the dismissal, he approached us for help, and we took the case to court. All he got was the pay, the severance pay, but it was regarded as fair dismissal. It's just like paying him off in a legitimate way. For those who have handled these cases, they would know that the unionists are suffering a great deal, and the unscrupulous employers would be tainting the reputation of the unionists. This unionist worker did manage to take the case to court, but there have been so many cases in which they couldn't do it. Now, in some cases, the employers would try to victimize the unionists. The non-unionists would get the promotion instead of the unionists. Under the existing ordinance, we cannot come up with evidence to sue for discrimination. There is an urgent need for the legislation to be reviewed. Should we increase the penalty? Should we increase the penalty to such a level as owing wages in arrears? And until we have collective bargaining power in Hong Kong, however much we change the legislation, we cannot put a stop to this discrimination against union activities. Right, next, Democratic Party, Mr. Edmund Lee, Community Officer. Well, we're talking about protection for trade union activities. In fact, the workers' rights, the people's awareness, I doubt how much people are aware of trade unions. They think of trade unions as providing snake feast, snake soup feast, and so on. This is not a problem for the unions. The problem is the Labor Department gave the definition regarding the trade unions. We don't have collective bargaining power. The workers don't enjoy any power, and the unions are really getting stuck in a rut, and they become the organization of entertainment activities. Now, we talked about 418 threshold. The Labor Department seems to be oblivious to the plight of the workers. We are heightening people's awareness of the trade unions to heighten the awareness of protection. What has the Labor Department done? Now, there is a paper today which says that a bill will be presented later on this year to give greater power to the judges. Many people approach you for help. How much help have you offered? In 2006, I was studying for a sub-degree, and I was a part-time worker taking bets in the jockey club. But the pay was so horrendous. We didn't have any WhatsApp, we didn't have any discussion forum. We tried to form a trade union, and no sooner had I formed a union, then I was dismissed. From the time I gave a statement to the time I pursued my compensation to the time we went to the High Court, I mean, I did everything all the way, every step of the way through. The Labor Department has not done anything at all. What have you done to safeguard their interests? None whatsoever. On one occasion, I met the then Commissioner for Labour, Mr. Matthew Cheuk-yan. I brought this case up with him, and I told him about the flaws and inadequacy of this trade union ordinance. I asked him to review the ordinance. All he did say to me was, get on with the study. And this is very much the attitude of the government. Don't harbor any illusion. This is my advice for the deputations today. Right, next, Hong Kong Jockey Club Employees Solidarity Union, Mr. Chen Ying-kit. Well, we have serving jockey club workers and ex-jockey club workers here. In my capacity as chairman of the Jockey Club Employees Union, I like to say that unions in Hong Kong are in fact protected by Hong Kong legislation and International Labour Convention. But a labour union doesn't have to be on a collision course with the company. It can collect the employees' opinions and smooth out the governance in the company. But the union is sandwiched between the workers and the management, and they're squeezed and they have the power slashed, and they don't pin very high hope on this system. And this is a system that has been emasculated, and there are so many conflicts in the company, and all they can do would be just to stage a strike. As I said, an effective union would be playing the role of a bridge between the company and the workers. I would like to urge the administration to legislate for collective bargaining power as soon as possible, and to empower the unions for them to play a bridging role between the management and the workers. I am concerned about the School of Monitoring incident. someone was sacked for forming a trade union. This is a naked crackdown on unionization, and this is against the law. This is suspicious. There is suspicion of breaching the law. And I urge the administration to investigate into this in order to safeguard the interests of the workers. Finally, I'm grateful to members who categorize the Jockey Club workers, part-time workers, as and-nothing people. I think we do need to legislate for collective bargaining power, and I urge all legislative members to urge the administration to go down this path and safeguard the interests of the workers.
Next, we have Ms. Wang Hanglin from Education Employee General Union. Thank you. When you stand out, you will be attacked is very common in the education sector. Unionists are discriminated against and isolated, oppressed at workplace. We suffer from torture mentally and physically sometimes. Sometimes you get to be discriminated or isolated by your co-workers, and your job at worst cannot be kept. Why? It's because we lack protection for workers to take part in unions. There are still lots of loopholes under the current legislation. For the officials responsible, they simply check their responsibility. They just simply let things deteriorate. They do not respond to our urgent needs. And in a way, they are damaging harmony. Under Section 21B(1), discrimination is not touched upon in the EO. Rights and discrimination are two different matters. I don't understand why they do not touch upon it. Without definition of discrimination, we do not know when the Labor Department will intervene and investigate. Without such legislation, how can you enforce the law effectively? Has the LD prosecuted any employers who discriminate against unions? I don't think so. Leaving discrimination out is really ridiculous. If you go to the Equal Opportunity Commission, you get a very clear definition of discrimination. It's only with a clear definition that you can enforce the law effectively. But in the labor legislation, things are really fussy, and it's hard for you to collect evidence, let alone prosecution. I really doubt the LD's commitment to crack down on discrimination. For the $150,000 as compensation, it's not deterring the employers at all. So may I urge you to respond to the current labor market situation and make amendments accordingly. With all these loopholes in the legislation, the government claims they haven't received any complaints about this matter. This is ridiculous. You don't have any complaints because you leave things as they are. You are creating this spreading effect. And the workers do not get any protection under the legislation. May I urge the administration to stop playing with words. You should plug the loopholes and legislate to protect the workers, so that they will not be discriminated against. Thank you, Ms. Wong. And then we have Mr. Cheuk-yan from Government Educational Staff Union. Thank you. Good afternoon. Our union thinks that the protection can be realized in two ways. First, clear legislation and clear penalty section. Clear legislation under the EO, you focus on those workers who are dismissed because they get involved in unions. You leave other areas untouched and unclear. and there is no civil remedies for these workers, you then propose amendment. We agree with this proposal by the panel because you're actually plugging the loophole of the burden of proof. Government's reply is disappointing. You do not consider the discrimination suffered by workers dismissed as a result. Now, in the Education Bureau, what happens to the unionists? Earlier on, at a work meeting, a unionist was ordered not to follow up and discuss complaints against the department. And the government says that the interests and rights of the worker has not been affected, and so the complaint was not substantiated. Is it only that when someone is dismissed that his rights will be protected? This is a kind of discrimination which does not result in dismissal. Mrs. Share and Mr. Matthew Cheung have been commissioners of labor, but they allowed such incidents happen. The LD said it will protect workers so that they will not be discriminated against when taking part in union activities. But the problem lies in burden of proof. Even if you legislate for the amendment of EO, you are not actually rectifying the problem. It's just that you change a death penalty to putting someone on parole. So you're not actually doing something effective. Because of the time constraint, I'll stop here. I'll submit the remaining in written form. It's now 6:30. I'll extend the meeting for 20 minutes so we can have some time for discussion. And next, we have Mr. Chen from Union of Hong Kong Dockers at Kwai Ching Container Port. We see a great contribution is more or less the same like the Hong Kong Exchange Square, or the Hong Kong Exchange. We see a rise in business, not fall. Behind the fruit of economic fruitful result, the workers are working round the clock. You don't know how hard their lives are. Since the establishment of our union, we protect the rights of the workers, of the dockers, so that disputes over working hours, safety, and wages can be resolved. But every time when we issue letters to companies for discussion, we get rejected. We do not have any legislation for collective bargaining powers, so the employers will simply ignore us. Workers may stand out to fight for pay rise. At the beginning, they thought nothing would happen, but after that, they are being punished. They will be dismissed because of some silly reasons. So people are getting worried. In our trade, if you stand out from the crowd, you will be targeted, you will be attacked, you will be dismissed. You do not get severance payment, another compensation. And even if you want to get back to the trade, it's hard because your name is on the blacklist. You are labeled as the troublemaker. So a unionist cannot exercise his rights. They are being fooled around, they are being threatened, rumors are thrown about. So they cannot openly take part in union activities. If the employer want to dismiss you, then they will not tell you you are dismissed because you take part in unions. They will give you all sorts of excuses in dismissing you. So the legislation might just as well be not existing at all. It's hard for us to tell whether to establish whether the worker is dismissed because he takes part in union activities. So we urge the government to put in place better protection, especially for dockers, so they can take part in unions to express their views. LD and other departments should step up inspection and investigation. You should also disseminate the message in the container port. At the end of the day, you should legislate for collective bargaining powers. We hope in this term you can start consultation and collect views for that legislation. Next, we have Mr. Chen Yichun from KMB Staff Union. Good afternoon. In 1988, we set up the union, and 25 years have passed. We have been registered as a lawful union in Hong Kong. Well, the past 20-odd years were a hard time, and still the employers would not recognize our position. We cannot negotiate with them. In the early 90s, the number of drivers reached 5,000 in KMB. Union member numbers at 1,600 odd. Well, this is a very good figure, but the union was not protected under the law properly. We have experienced so much as unionists. In KMB, we suffer discrimination. Our power to bargain has not been recognized. Our rights haven't been recognized. We haven't got any meeting with the employers. When we ask for pay rise, we can only submit our petition letter to the company. We can only express our views via the media. But we haven't lost hopes. We still fight for the interests of our fellow colleagues. Things are not healthy. The employers will not listen to us. But is this practice good for a good company? A company that claims to provide quality service to the society? The management doesn't know what they are supposed to do. Longwin Union has been expressing their views on platform used on buses for disabled people, but their views fell on deaf ears of the company. Their views are not taken up. So the drivers suffered from work-related injuries as a result. And the government is just sitting here and turn a blind eye. We have 4 suggestions to you. Legislate so that the unions will be recognized. When a member of unions reach a quarter of the total population of employees, their lawful position should be recognized, and we should be entitled to leave days should we be union members, because we devote our free time to serve the unions. So we should get pay leave days. Next, you should legislate for collective bargaining powers. Well, is it the case that a union is only should only exist if we get the endorsement of the employers? No. So we urge you to change the law to enact for collective bargaining powers.
Well, thanks very much, Deputations. Kwok Wai Keung, Leung Yu Zhong, Pun Siu Ping, Chen Chi, Raymond Chan would like to speak. 4 minutes each, please. The administration has to give us a reply regarding the statistics that the deputation sought over the years, how many complaints have been received, how many prosecutions, and nothing in the paper has been shown in this paper. Mr. Hui, from 2005 to 2012, for this span of 8 years, we have received 50 cases of complaints regarding trade unions, 41 of which were investigated into. The remaining, some union members refused to testify. 3 has gone beyond the prescribed time. Now, for these 41 cases of complaints, from 2005 to 12, we have prosecuted 5 cases, 2 of which were successfully prosecuted. They were convicted. So there you go. You have the prosecution. The failure rate is exceedingly high. 5 out of 41 have been prosecuted. 36 have been eliminated by the Labour Department, and 3 have been thrown out by the magistracy. And for the 3 cases that were convicted, $5,000 were slapped on as fine in one of the cases. Perhaps we should end the meeting at 7 because of the sheer number of members. Mr. Kwok Wai Keung. Chairman, the Labour Department told us that of the 41 cases, 5 were convicted. It goes to show that the legislation is there, but there are so many difficulties with regard to prosecution, and the unionists are facing grossly inadequate protection, and there is a need for us to step up the law enforcement and monitoring. We handled a number of cases in the recent past. The Productivity Council is experiencing a similar situation. The union representatives are being sacked successively. A couple of them have really gone. Now we are trying to ascertain the reasons behind this. Well, people can can resort to all kinds of tricks. They are not really dismissed straight away, but they are put. The life is made so difficult, and they're vilified, they are reprimanded, they are posted to unpleasant postings, and this is making the unionists lose their dignity. In worse situations, they would. I mean, over the past decade or so, they have been given really outstanding appraisal, but in the past 1 or 2 years, they have their appraisal marked down so badly. Now, you're nodding your heads. I mean, there were 5 cases of prosecution. What should be there that isn't there, in the opinion of the Labour Department. In another case, we handled a strike regarding a lift company. The employers refused to talk to the unionists. Well, you may argue that the employers can choose to liaise with whoever they desire to meet. I mean, that would constitute discrimination in itself, because they are getting across a clear signal that union members will not be entertained. There is no point forming any trade unions because the employers are not prepared to talk to them. In a way, they're trying to deter people from forming themselves into unions. If I may put this to the Labour Department, does this constitute discrimination? They refuse to meet the union members. The life is very hard being a unionist. We have to wait all day long for a reply as to whether we would be entertained. I look forward to a reply from the Labour Department. 15 seconds, please. Whether unions are recognized and whether the legislation is not worth the paper it's written on because of the low rate of prosecution. Well, I may need to spend more than 15 seconds. First of all, there are 3 levels of protection. The first one is protection of trade unions. They will not be subject to criminal or civil prosecution or civil litigation. And anybody who is discriminated against for being part of the union can seek legal civil remedy. Under the employment ordinance, it is stipulated that because someone is dismissed because of being involved in trade unions, then the onus of proof would be on the employer. They have to show that there has been no discrimination. So the onus of proof is on the employers. The third one is criminal prosecution. Like any other prosecution in Hong Kong, the onus of proof would be on the prosecution side, and the burden of proof would be higher than a civil remedy. So that there are 3 tiers of protection. In other jurisdictions, they don't have this tier of criminal prosecution. It is difficult indeed to instigate criminal prosecution, although we would still pursue that. Mr. Leung Yu-chung, Chairman, in the paper, the administration said that they would come and talk about the legislative amendment, but it doesn't mean anything at all. Basically, for reinstatement, the court can issue an order of reinstatement without seeking the consent of the employers. I think this is really superfluous. This is ridiculous. For reinstatement, why do we need to have the consent of the employers? It would be really a bit of a surprise if you don't really want to amend it, because the original provision is really nonsensical. There are 2 problems today. What do you expect the unions to do? If the unions don't enjoy a legal status to be on the same footing with the management when it comes to negotiation, what's the point of having these unions? Now, not just pay rise. On any other issues, if the employers don't want to talk to the unions, what else can you do? And they say that there is no discrimination. It's just that they're giving them a silence treatment. The unions are as good as nothing, really. So what do you expect the unions to do? Second, you may say that there is legislative provision regarding discrimination against the unions, but you cannot protect the union spokesman from being dismissed. There can be no reason cited. All they need to do is to pay you off. Now, for these on the front line who are negotiating with the management for the sake of the workers, how will you make sure that they will not be threatened? Mr. Hui, in relation to protection, as I said, by the middle part of this year, there will be an amendment bill to the employment ordinance to allow the Labour Tribunal to, without the consent of the employers, mandate reinstatement. Well, you don't have to talk to say this. I already know this. Well, the other thing is the role of trade unions. In terms of labor relations, and we have been promoting labor relations all these years. In terms of labor dispute, unions do play an important role. Now, how much role can a union play? I think it all depends on how much support that the union can garner. If there is overwhelming support, it would be difficult for the management to ignore it. Well, that's precisely why the unionists are sacked and a ring of terror, white terror, is imposed. Sorry, Mr. Leung. Well, not just the union leaders are sacked, those who are supporting union will be sacked. How do you expect people to support the unions? You said that the unions are playing the role of liaising with the management. Can this be achieved? If they don't take any action, the management would refuse to engage in any discussion. Well, without any protection, how can you encourage the unions to engage the management? Mr. Hui, as I said, there is a three-tier protection. Well, if you dwell on this, please save it. Mr. Chen Chi-chin, Mr. Pun, well, I think it is an important important element to protect the right to strike, the right to form unions. Now, of these 50 cases, only 2 were successful. You said a moment ago that the unfair dismissal will become part of an amendment bill going forward. But at the present moment, criminal prosecution would be very difficult. It would be difficult to get the proof. Now, with this poor success rate, will you conduct any review under the ordinance? What else can be done to make improvement, to give full effect of the law? Will you conduct a review? Mr. Hui, Chairman, when it comes to protection, we're not merely talking about a criminal prosecution. Now, with the civil remedy, we have expanded the reinstatement right, and failing that, there can be additional penalty, or failing that, even there can be a criminal liability. All these deterrents would improve on the rights of the unions. I must say that when it comes to criminal prosecution, the onus of proof lies with the prosecution and might present certain challenges. So we would start with the civil remedy. We would increase the deterrent effect to protect the workers. If I may add, Chairman, the civil remedy, we have been arguing over this for some considerable time. We have taken a little step forward. Now, we have been talking about the reinstatement for so long. Under the trade unions ordinance, since its inception, nothing much has been changed. Since the effectiveness is so limited, it is time the government take a look at the situation. Right, criminal prosecution, will you look at this in earnest? Mr. Hui, however much we change this element, criminal prosecution means that it is for the prosecution to start the prosecution. You are prepared to change? Well, are you saying that you are prepared to change even though this doesn't bring about much changes as a result of this? Are you prepared to look into this, Mr. Hui? Later on this year, after the introduction of the amendment ordinance, we will review the effectiveness, and then we see how we go from there. Mr. Raymond Chan.
If the government is not committed to cracking down of discrimination, then it's just a waste of time and resources. In the paper, You talk about the background. You said that there is no evidence to show that the employers are intervening with unions, and you haven't got any complaints about that. That's why there's no need for legislation. This is what's said. Now, we are urging you to, and we are asking you to give us the data. It's only then that you give us the data. All right, we get the data, the figures about the complaints now. Do you think you have to legislate to crack down on discrimination? And you gave us figures from 2005 to 2012. 8 years, 50 cases. And every year you get only 6 cases. It's just a small figure, so you can say they may as well not exist. And you only got 2 successful cases out of the 50 complaints. Even with this low successful rate, raising the amount of penalty is not going to help at all. Raising it from 100,000 to 150,000 is not going to help at all. You have such a low complaint figures. Why? Because the legislation has loopholes. So those people who suffer under the law dare not raise their voice. They would rather go to work in another company. They would rather stay away from unions. They would rather not tell people they have been involved in unions. All these because they want to have a job. Do you think with these figures things are serious? You said there was no need to legislate for that, and has your position changed? Mr. Hui, over to you. Mr. Chen, you mentioned the paper and you said that there are no complaints. In fact, we're talking about the Convention number 98 of International Labour Organization. The party countries should prevent employers from intervening the unions with financial means. Well, at present, we have not got any complaints about that. So we do not have any employers paying to unions so that they can control the unions. So we do not have any of such complaints up to now. All right, this is the point I want to clarify. Yes, Mr. Chan, any follow-up? I was talking about the figures you mentioned on average 6 cases per year. Is it the case that you think it's not serious? Well, coming to the figures on the whole, number of unions amount to 180,000 members, 800,000, and we have about 200,000 cases of claims. 20,000. And so 6-7 cases per year of complaints. Well, cannot say that all the workers who are discriminated against come to us to complain. But the average 6-7 cases for them, not all of them stand on their own 2 feet. Now, the complainants may not be a unionist. They may not be involved in the setting up of unions. With the low figure, it's all because they do not have full protection, and they think that even with complaints, that cannot take their case any further. That's why they save the step. So will you do some soul searching, or will you look at the matter further? For the LWB or the LD, do you think it's because people think they do not get protection, that's why they do not come to you? Or the people do not think there are problems, so they do not complain? The average 6-7 cases per year of complaint, well, they do not come here for criminal prosecution. They come to us for civil remedy. For civil cases, it's for the employers to prove the case. The burden of proof rests on the employers. So the legislation actually helps employees to advance the case in remedy. We will also step up protection for employees in the future with the amendment. Mr. Tang. Well, for our unions, we dealt with several cases of major labor dispute. Unionists would like to negotiate with employers, but the LD is simply working as a messenger for the employers. You do not represent the interest of workers. There are complaints. You try to whitewash the matter. You only have 5 successful prosecutions or 5 successful cases, and 2 of such cases were substantiated. How much manpower, how much resources have you put in to advance criminal prosecution? Is it enough, or is it the case that you do not have any officers assisting in that regard? Or is it the case that officers are so busy that they cannot do anything else? All right, about your establishment or manpower. Labor dispute unit is responsible for handling the complaints. We act as mediators. If we suspect law is broken, the case will be transferred to claims unit. And officers do not simply look at the discrimination suffered by unionists. They will investigate into the case as a whole. We have our own prosecution unit. How many officers are actually working on this to protect the unionists and to work on their prosecution? You already spend manpower to support unions. How come you do not have a unit especially to protect the unions? Do you have such a unit? Well, we receive complaint, and we receive 6 to 7 complaints on average every year. You heard from deputations, things are ridiculous even if you take the case all the way up to high court. The workers have already lost their jobs, and they have to spend so much time to fight for their interest. Now, the legislation are in place, but there's no support for the workers. Now, coming to the reinstatement order, what sort of support do you have? Do you provide? Do you have additional manpower to carry that out? Any? We do not have any plans to expand our manpower. We will rely on the manpower from the prosecution unit, the labor dispute unit, and the complaint handling unit. We do need figures to back up our application for expanding manpower. We have to get hold of these reasons before we can come to apply for extra manpower. And at present, we do not see the need to expand our manpower. You do not want to see such complaints. That's why you do not plan to expand manpower. You do not take up publicity work in this. I do not see any notices or posters posted about protection of unions. You do not want to have publicity, and you do not plan to expand the manpower. Mr. KK Kwok, thank you, deputations, for coming here. Well, you have only 50 complaints and only 5 resulted in prosecution. The figure is really low. Well, this is not up to scratch for any law enforcement agents. If we're talking about the police with this figure, then there must be something wrong with the prosecution. Number 98 and 87 of the ILO Convention is very clear that the rights should be protected. Now, with the low prosecution rate, are you going to have any review? And what's the result, if any? People have the feeling that the LD is there to protect the employers, not the workers. Do you have any figures to show us that you will do something to raise the prosecution rate? Mr. Hui. Well, you mentioned the conventions under ILO. In 2012, ILO rolled out number 98, and a report was published as a result. It looked at the situation of how the convention is launched in different countries. Concerning discrimination against unions, the view is that in some jurisdictions there are a criminal prosecution against such discrimination, but the burden of proof or proving the case is difficult. So the difficulties of proving a case is not alone in Hong Kong. This is recognized by the ILO. So in the report, it suggested that party countries should resort to civil claims and reinstatement order to address the discrimination, and this is what the direction of the LD. In the middle of this year, we will apply for amendment of the EO so that the Labour Tribunal can make a compulsory order for reinstatement. So it means the LD is giving up on legal justice. Yes, we understand it's difficult to prove your case in the criminal sense, but it all depends on the threshold in the legislation, and it also depends on whether you have the resources to carry out the prosecution. LD, you are the responsible department. Do you have any plans for further amendment on the criminal side? Do you think, or do you consider you will raise the threshold? Well, you have all these incidents concerning the Hong Kong SM, and it shows you that you are not doing a good job in terms of prosecution. So are you going to lower the threshold in criminal prosecution? We'll go about in two ways. We will improve the laws in civil proceedings, and in the criminal sense, whenever there is a complaint and whenever a worker is willing to testify, we will definitely investigate every single case. As for sufficient evidence, we have to seek the legal advice from DOJ. I'm simply asking him something about the legislation. Are you going to review the legislation? We will first look at how the compulsory order for reinstatement works to see whether it has any deterring effect on the employers before we move further. Now there's still some time. I'll raise my questions. Members asked you about the prosecution rate, and you're not doing a good job there. You're just a paper tiger. You have 50 complaints and only 5 resulted in prosecution. And the most important cases is that 49 pilots were dismissed in Cathay. Why? Because they were dismissed. They were dismissed because they got involved in trade unions activities. But the 5 prosecution cases do not cover their case. This is such a high-profile case, and it did not result in a criminal prosecution. Now, the message is very clear. You are not committed in your cause. Now, I'm really worried about the driving instructors who are in Hong Kong SM.
What is the investigation like at the moment? This is again a pretty well-known case. What is the position in this regard? I know that you won't go into individual details. So what is the progress in relation to prosecution? Furthermore, when it comes to reinstatement, Now, if there is no reinstatement, there would be an additional $30,000 penalty. So this is really a pseudo reinstatement right. Now, the judge may impose a reinstatement, but if the employer doesn't give effect to the reinstatement, then it should be regarded as a contempt of court instead of just stepping an additional fine. Third, any civil remedy for non-dismissal discrimination, like you are posted in the middle of nowhere, you are demoted, or you are putting through some psychological pressure, or you're marked down in your appraisal, so much so that you won't get a pay rise and so on. I mean, would there be any civil remedy? Mr. Hui, whereas Chairman said we won't go into details about individual cases. Now, all I want to say is we would investigate into all complaints, and with sufficient evidence, we would instigate prosecution. Second, reinstatement. If the employer doesn't comply with the order of reinstatement, there would be a 3 months' worth of pay or $50,000 fine. And this represents the consensus at the LAB. This has been dragging on for so many years because the LAB did discuss all these issues. Now we have achieved a consensus that if there is non-compliance with the order, then there would be an additional fine. Of course, we would have regard to the situation as a result of the implementation of the ordinance. Non-dismissal discrimination. Now, of course, one can claim for compensation if one is worse off in terms of the employment terms, one is sustaining some losses. Then under the existing employment ordinance, there is a provision to say that if the terms of conditions are modified in such a way that one becomes worse off, then claims can also be made. That's not employment ordinance, isn't it? It is the employment contract. Yes, there is a provision under the EO, because under the EO there is a prohibition on the part of any single-handed change of the contract. But they are making changes to the contract, and they can be prosecuted. Now, in some cases, it's not just it's not a change in the contract. If you are marked down in your appraisal report and you don't get a pay rise as a result, there is no protection. No, nothing like that in the employment ordinance. Well, I know the law better than you do, but will you be amending the law to put in place some compensation or claim mechanism? Mr. Hui will look at the situation as a result of the implementation of the law. Right, we've got over the time. Thank you very much for coming. Deputations, I'm afraid we cannot have any more deputations. Thank you all very much for coming.